Are you ready to overcome the complexities and burdens that come with your success? Join the team at Centura Wealth Advisory in the Life Liberated podcast. Now, on to the show.
Hello and welcome to Life Liberated with the team from Centura Wealth Advisory. Hosting this podcast is Bryan Schick. And Bryan, I see you have a guest with you. So why don't you introduce your guest and get this podcast started?
Yeah, looking forward to it. Thank you for the introduction. My name is Bryan Schick, Vice President of Insurance and Strategy at Centura Wealth Advisory. I'll be hosting the podcast today. Today, we're going to talk about QTIPs, what are they and how to use them. And we have a special guest with us, Daniel Stolfa, who's Senior Wealth Advisor at Centura Wealth Advisory. He's an estate and trust attorney with years of experience in this field. Looking forward to his insights on a QTIP, how to use them, pros and cons. And Daniel, if you would just spend a few minutes and introduce yourself, let our guests and listeners know a little bit more about you, please.
Thanks, Bryan. I appreciate it. Thanks for having me on today. As you mentioned, I'm an estate trust attorney with an LLM in taxation. I've worked as a lawyer. I've worked in public accounting. And for the last 21 years now, I've worked in the wealth advisory side, helping ultra high net worth folks plan out the rest of their lives and then how to leave their legacy. So happy to be here.
Great. Looking forward to our podcast and your insights today. Thank you for your time. Well, let's start off. We're going to talk about a QTIP. So let's define what is a QTIP, Daniel?
So for anybody who's here today, because they think we're going to talk about cotton swabs or the better way to clean out your ear, I'm sorry, that's not this podcast. So in trust parlance, a QTIP is a Qualified Terminable Interest Property Trust, and it's a device used to transfer property between spouses to help maximize estate tax transfer. And in certain cases that we're going to talk about today is also pretty useful in income tax planning. So it's a type of marital trust, and we'll spend a little time talking about that today.
Great, thank you. I thought we'd always start off with a little perspective on what the podcast is about so our listeners will be in tune. A little bit about Centura's clients. We typically deal with three types of clients. All of them would have $2 million of income and $20 million or plus of net worth, divided into three categories. Founder-led businesses. A lot of those businesses we work with may be in the process or thinking about a disposition or transfer of that business. We work with public traded companies, C executives, if you will, CEOs, CFOs, COOs, et cetera. And then we work with high net worth families. And typically those high net worth families would have a higher net worth than 20 million. But getting into it, so Daniel, what are some of the typical issues that our clients come to us to solve, and how might you work with them or suggest that they work with us?
So for our clientele, based on the way you just describe it, it's kind of, the three main things are taxes, and taxes. And that's a little bit more cheeky than it's supposed to be. So it's income taxes, estate taxes, and gift taxes are traditionally what we're dealing with. Ever-changing system. Anybody who's following the news right now knows there's a lot of discussion around the entire regime and what's going to happen to it. But for what we have and for what we know of it, we work with our clients to come with the best solution possible. It's kind of that old saying, it's not what you get, it's what you keep. So we want to make sure that we're getting the best possible outcome for all of our clientele in this regime and in tax regimes going forward.
Yeah, no, great. Thank you for that. I know there's a lot of solutions, a lot of different problems, if you will, that we solve for clients. And we always look at the appropriate solution based on the fact pattern. We do a lot of research on fact patterns and gathering information so we can be of best service to our clients. Let's talk about California domiciled residents, if you will, clients. We deal with a lot of those in our practice, and the state of California has some very particular state income, state capital gains taxes. So we're all pretty familiar with federal estate tax planning. A lot of firms do that. I think a differentiating factor in our firm at Centura Wealth Advisory is the detail in the state level planning, particularly for California clients. So could you address some of those specific issues?
So, the main part is that we're dealing with, in California, the highest personal income tax state in the country. There's a number of them. I sit in Minnesota. We're, I think, in the top three. There's New York. You're very fortunate down in Texas in that you don't have that issue. So part of what we're dealing with this QTIP planning that we'll be discussing today is the intersection of income tax planning and estate tax planning. So while a QTIP is most commonly used as an estate planning device in certain situations and in the right income tax environment, and California is certainly one of those. It's a situation where it can have a mutual benefit. So, just to level set for our high income taxpayers on the federal level, when you involve the net interest tax, you're dealing with a top marginal bracket now of about 41%. Now that may change, but that's where it is now. When you're here in California with the surcharge, you're in right at around 13%. So somebody in the highest income tax bracket in the state of California is paying over 50% in income tax. And for a lot of people, that's an undesirable result. And so to the extent that we can, and to the extent that it's allowed, we find ways to mitigate that and to reduce their exposure.
Right, and could you spend just a minute or two on California capital gains tax? That seems to be an issue we hear from some of our clients.
So the problem is similar in that the federal capital gains tax rate is significantly lower. In California, it's not the case. So that when you add in all the 20%, the 3.8%, the California tax, somebody in California paying capital gains tax is paying in and around 40%. So again, it's a very high income tax, including capital gains tax regime. And for a lot of people, they want to find ways to plan around that.
Great. And you mentioned that additional 3.8% tax, right? And that's based on income and again, increases the potential cap gains tax rate for our clients to be mindful of. Well, why not just leave California? I mean, and I don't mean that in a jokingly way, but are there ways or things to think about? Can you transfer a specific type of asset outside of California?
It's a really good question. I mean, it's actually something that we do a lot of planning with for folks who live in high income tax states. So you can physically change your domicile, but it requires a lot. I mean, you physically have to move. So it's not, just a matter of, well, if I spend enough days outside of the state, or if I just tell the state that, I live in Nevada now and not in California anymore. They're a little bit more clever than that about how they track these things. So physically changing domicile, that's really another podcast entirely. It's a complicated process. It involves an awful lot of facts and circumstances, but one of the things we talk about is you really do have to change your resident state. So for most part, it's an intent test. Where do you live? Where do you vote? Where do you register your cars? Where do you go to religious services? So if you want to leave, it's certainly a planning tool. But if you're like me and like most people, you like where you live. That's why you live there. Your family's there. Your job's there. All of your life is associated around that. So physically moving is an option. It's a complicated one, but certainly something that lots of people contemplate. But I think to what you're talking about is what can we do to move parts of our life outside of the state? And so that's really the difference between tangible property and intangible property. So, those things really are just, what they mean. Tangible things you can put your hands on. So, you can't move your house. I mean, as much as people I'm sure would love to, you can't pick up a big chunk of dirt and move it into another state. Physically moving yourself, we talked about physically moving a business is one thing. But when you move into the intangible side, your accounts, your investments, things that don't have a physical presence, there is an opportunity in some cases to shift those around. And depending on what the shifting is and how you do it, it can have significant income tax benefits.
Yeah, and then I think another thing you might be alluding to is California is very specific on what I'll term California sourced revenue or income, and maybe just another minute or two on what that means and how that relates to intangible assets.
So the easiest way to think about it is, as an individual, if you're a California resident, every single dollar you earn from anywhere on the planet is considered California source income. So business owners out there, people familiar with the idea of source tracing, if you can attribute your income to different states, you may owe tax in those states and may not owe tax in your home state. But for an individual who's a California resident, the state does you the gracious, or some would say ingracious, task of saying you don't have to track it because it's all sourceable to you. So one of the things we look to do is find ways to separate the individual from the income and potentially move it outside of California if it's possible.
All right, well, so let's get into it. Why don't you walk us through again, what is a QTIP? You defined it, but we can define it again. I think that's always helpful to add perspective. And then walk me through the parties of a QTIP and kind of overview of how it works, how you set it up, and different considerations, maybe even different state domiciles of a QTIP.
So again, it's a technique that's very commonly used in estate planning, and it's most commonly used in second marriages, third marriages, blended families, because what it does most specifically is it provides that we use these terms interchangeably, the grantor, the settlor, the donor. I mean, you'll hear all of them used. Technically with the trust, it's the grantor, but it's the person who sets up the trust. So we'll just use you as an example, Bryan. You are going to set up a QTIP trust. The reason why you do it is you want your spouse to have access to funds for the remainder of her lifetime so that she can provide for her lifestyle and live in a manner that she's become accustomed to. But you want to be able to control what happens to those assets after not only your death, but after her death. So the most common reason that QTIP is used is that as long as it provides lifetime income to the surviving spouse, it provides the grantor, or it provides you the ability to determine where those assets go. So in most situations, when you make property available to somebody, if you transfer it to them, it becomes theirs, and they have then the ability to decide where it goes. So in this situation, it's that similar setup, but the main reason why we're using it is that the way that the trust treats income is different than the way that you and I treat income. So inside of the trust, capital gains is actually split off from interest and dividends and what's considered ordinary income. So the advantage being here that if we move the trust outside of the state of California, and for our purposes, we'll use Nevada because it's the one we use most often. It's a no income tax state, and it's one of the top 5 states in the country as far as trust law goes for making things flexible and desirable to trusts. So you set up this trust in a friendly domicile. And again, we're going to use Nevada. So you set up a Nevada trust. You set up with a Nevada trustee, because one of the things to keep it outside of California is that there can't be a trustee associated with the state, or they'll be deemed to be inside of the state. So we set up a trust outside of the state of California and Nevada. We name a Nevada trustee. I would recommend using a corporate trustee. I think about 80 to 85% of trusts established in the United States still use a family member. It's kind of the old, I picked Uncle Bob and he's going to do it. If Uncle Bob is a qualified trustee, absolutely. If not, these are pretty complicated. And so having a professional would be a good idea. But again, the advantage being you transfer those assets out into the trust. And as long as they're out there long enough, and for California, that's 5 years, when you sell those assets, because of the way the trust income is calculated, the capital gains are not part of the income that's distributed back to the spouse. They stay in the Nevada trust, and they're not subject to California income tax.
So let me summarize what I think I heard you say. The QTIP is a form of a marital trust, I think is what I heard you say, but maybe a little differentiating fact. In a marital trust, my spouse, if I were to predecease her, could have control over where those assets may be distributed. Where in a QTIP, if I understand what you're saying correctly, that me, setting this QTIP structure up, my wife would have lifetime income from the QTIP, and then upon her passing, the trust document would control where those assets would be distributed. Is that correct? Do I understand what you're saying?
It is correct. I mean, in every case, the trust document controls, but in the specific case of a QTIP, it's designed so that the grantor of the trust, you ultimately are deciding where all the assets go, and not like a more traditional marital trust where oftentimes they'll give a power of appointment to the surviving spouse. A lot of times in a marital trust, there'll be an outright distribution to the surviving spouse, which they can then pass on their own. So in the QTIP situation, the trust is deciding where it goes, but you're the only one who is involved in setting that up.
Oh, thank you for that clarification. And just to be clear, would you touch on the appropriate type of people or net worths that people look at? Clearly, our client base has the net worth and income that we could consider a QTIP if it's right for their planning techniques. But you mentioned, I think, second marriages, perhaps. Could you kind of go a little more detail into that? What appropriate client fact pattern might be?
So, my wife always teases me because this is the number one response that comes out of my mouth with questions like this is it depends. And so it's why we are doing this, why we advocate getting in touch with somebody like us, somebody at a Centura. If you're working with a really good estate planning team, getting in contact with them. It depends on what you're doing and what you're trying to achieve. So, the tax side of it is important, but we don't want to let the tax tail wag the dog. So in a lot of cases, if you're over the allowable federal exemption amount, these things become more attractive. That's traditionally where marital trust planning comes in. You've used up all of your lifetime exemption, and you want to take advantage of the fact that you can transfer unlimited amounts of money to your spouse. But in this specific situation, when we're really dialing down into the pre-death income tax planning side of it, it depends on what assets you have to transfer, what kind of capital gain is built into those, what your lifestyle looks like. There's no real hard, fast limits or kind of hurdles as to what kind of income and net worth you need to have. Certainly, it's much more likely if you fit into that basic client profile that you described earlier. The more you have, the more planning opportunities you have. This is an irrevocable trust. So when you transfer the assets to it, yes, the income will come back. But in most cases, depending on how the trust is drafted, those assets are going to be primarily unavailable to you and being held for the benefit of whomever you provide as the remainder beneficiary. So, if you have a $20 million net worth and you're comfortable moving $10 million of that out of your estate right now because it looks attractive from a couple of different income tax and estate planning numbers, and it's something that fits in your lifestyle, it could work. You could be worth $100 million and I could pitch this to you all day long and you could say, you know what, I'm not going to do that. So it's good to know how they function and why they function, but as with everything else, it has to fit into your plan, into your overall, desires and needs. And that's why we highly recommend putting together a qualified team of professionals who can really help you sit down and figure these things out and work them into your overall needs.
No, I appreciate you saying that. It's one thing I think we do extremely well at Centura Wealth Advisory is coordination of your professional advisory team with us, providing oversight and guidance. And as with any planning strategy, it deals with facts and circumstances. Just because we're in the tax world, we like acronyms. A lot of people used to use what was called an ING strategy, particularly in California. Why don't you tell us a little bit about an ING strategy, and is the QTIP an alternative to the ING strategy now?
So an ING is an incomplete non-grantor trust. Like you said, we love our acronyms. And for most people listening to this outside of California, it's still a valid planning technique. It's simply that the state of California, in their desire to generate revenue, went after this strategy, and the FTB specifically ruled against it. And so while most people out there in the world treat it as a non-grantor trust, that's the N in ING, the state of California has simply disallowed that. And they said, if you establish one of these, they will treat it as a grantor trust, and therefore the income will be taxable to you as if you hadn't made the transfer. So it's still a valid strategy. It's simply that the state of California has chosen to disallow it for California residents. So it's no longer a planning technique. It's a different trust technically than a QTIP, but for all intents and purposes, we're using the QTIP now for California residents to try to achieve a similar result in the income tax planning world. So, if you're outside California and you're trying to decide, should I do an ING trust or a QTIP trust? There again, sit down with some people who can help you guide through those, because the income tax treatment may be similar, but the estate tax treatment of it could end up completely differently depending on your situation.
Well, this sounds great. It sounds simple, but with all planning, we know it's not simple. We have to pay attention to the details and outcomes and potential solutions if changes were deemed to be necessary. Can you kind of walk me through key planning elements of the QTIP or drafting suggestions you might make for clients looking into this strategy?
So my number one answer to both of those things is make sure you're working with a highly qualified estate and trust attorney who has done many of these before. It's a little personal pet peeve of mine, but estate and trust work in the legal world always seems to be and I do that too.
Mhm.
And that's not, no disrespect to people who are doing it, who are good at it, but make sure you have somebody who's really good at it, because this is very complicated. So conceptually, it makes sense, and we try to make it as easy to understand as possible. But the actual drafting and execution of the document is a very technical thing. And if it's not drafted properly, it will not produce the net result, because it will basically be found in error and disallowed. So the drafting of it, making sure that the income interest is written properly, making sure that it's qualified properly, making sure that the dispositive positions are properly set up. But a good attorney will know how to do that, and you won't have to worry about it. So make sure you have the right team, and that it's somebody who's done this before and can work it into your plan.
No, that's very insightful. Appreciate that. It sounds like there's a lot of parties involved, right? We mentioned the professional advisory team, CPAs, law firms, corporate trustee, perhaps, a lot of other parties involved. Could you spend a moment and talk about managing the assets within the QTIP and the coordination of the professional advisory teams?
So it kind of goes back to why I talked about, my recommendation that you use a professional trustee. A QTIP trust at the end of the day is a trust. And so there's an income beneficiary and there's a remainder beneficiary, and the trust has to be managed with both of those in mind. So one of the things that's common in a QTIP is that the income beneficiary is provided the right to demand the trustee to use some of the assets to be income producing. So a lot of times what would happen is somebody would say, well, I transferred this all in, but my spouse doesn't really need any money, so we're going to invest this all into growth assets that have nothing but capital gains, and the interest for the income beneficiary will be close to nothing. Most income beneficiaries don't like that, and so you need somebody who can balance those interests, keep it somewhere in a logical range. As an example, to say 50-50, so half the trust is income producing, half the trust is growth producing. But you want somebody who can make sure that they're doing that appropriately.
No, that's insightful. I think our listeners will really appreciate those comments. So what I hear you say as well as we do planning, the QTIP should not be the sole source of income for the spouse.
Generally not. I mean, again, if the right fact pattern turns up and somebody's that concerned about the final disposition of assets, it could be. In general, I'd say it's not, we're never a put all your eggs in one basket shop. Right. It just is not a good idea. There's too many different kinds of risks associated with that. So, but the level of what part it'll play in your plan depends on you specifically.
Yeah. And so let's talk about what could go wrong, or what can we plan for to make sure that this strategy works?
Well, the number one thing that could go wrong is that the trust is drafted incorrectly. And it doesn't function the way that it was intended to. So assuming that we find somebody who clears that hurdle, it's really a matter of fitting it into the overall plan. So, I mean, one of the things that we talk about with income tax planning is that we will commonly set these up during lifetime, or what's inter vivos, fancy Latin for during lifetime. And so the common estate planning role of a QTIP doesn't occur until somebody dies. And so the issue of divorce is a non-factor because one of the spouses is dead. If you set this up during lifetime, it's a great scenario, but like a lot of these other spousal trusts that are out there, it presupposes that you will remain spouses. And we all know that that's not the case 100% of the time. So as attractive as some of these techniques may look on the surface and from a tax perspective, if you have concerns of the longevity of your marriage, it becomes a less attractive technique, because if you fund this trust, this irrevocable trust, and you get divorced, those assets belong to your spouse. Well, not to your spouse. The income benefit belongs to your spouse, but the assets no longer belong to you.
Right. So, as with all planning, it's the operation of the plan that makes it successful. Very insightful. So, hey, I like this plan. I like it a lot. I think it's flexible. It does a lot of things for my family, my spouse, and my potential beneficiaries or heirs. I want to get started. What do I do? What's kind of the time frame to set one up? And could you walk me through that process?
So again, we'll go back to the old saw. It depends. Mm-hmm. If you have done, and I know you have because you're a good planner. So if you've done all your planning, everything's in order, all your foundational documents set up, you know what your assets look like, you know how your allocation is set, you know what your needs are for the remainder of your lifetime, and suddenly this becomes something that's intriguing. Reaching out to your advisor, reaching out to your attorney, getting started. you could probably get one of these done in a couple of months. It really depends on how complicated the trust document itself is. If the way that you hand out the rest of the assets is pretty simple, it's an easy trust to draft. If you're going to come up with some elaborate pot trust that has 45 to 50 people in it, and the shifting distributions, if so-and-so survives, and if they don't, it goes over here, that's going to take a long time to draft. So as with anything else, the best time to start was yesterday. The better time to start was, even before that. But start now and give yourself as much time as possible.
Yeah, and I think this year in particular, starting now is very important. There's a lot going on in the estate tax world that could change, particularly January 1 of next year. Subject for another podcast. But we could have an issue with being able to find advisors towards the end of the year if we want to implement one this year, correct?
Well, you're 100% correct. 2025 is going to be a terrible year to especially start estate planning, because there's an awful lot of people who are trying to deal with these potential sunsets in all the different arenas. And, what is it, March now? I figure if you don't have these things started, by April, May, I wouldn't realistically think that you're going to get them done. I mean, if you have a really great attorney on speed dial who will drop things and do things for you, good for you. And maybe that timeline shortens. But especially if you're going to need to do transfers, if you're going to need to do any kind of valuations, there's a lot. So right. The clock is ticking on 2025 already, unfortunately.
Yeah, well, Daniel, I really appreciate your insights today. I do have one follow-up question that comes up sometimes with our clients. And can the QTIP structure, if you will, can it sell assets or swap assets like other trust structures can, if drafted correctly?
As with all trusts, it depends on how the trust is drafted. So it's entirely common for trusts to allow for trustees to sell assets. I mean, that's part of managing a portfolio. They buy and sell things all the time. Swapping assets, same kind of thing. Unless it's disregarded or prohibited, it's generally allowable. But again, it's all in the drafting.
Well, Daniel, I really appreciate your time and insights today. I think it lends insight into the capabilities and comprehensive planning we provide for our clients at Centura Wealth Advisory. For listeners out there that are interested in the QTIP, we'd love to talk to you about the opportunity of looking at it, implementing it, and see how it might fit into your overall plan. And Daniel, thank you for your time today. I really appreciate your insight, and I hope listeners took away some unique insights that may impact their planning and their family and legacy as well. So thank you for your time, Daniel, and have a great rest of the day.
Thanks, Bryan. You too.
Bryan and Daniel, thank you so much. And most importantly, thank you for listening to the Live Life Liberated podcast with the team from Centura Wealth Advisory. If you've not subscribed to the podcast, please click the subscribe button below. This way, when the team comes out with a new podcast, it will show up directly on your listening device. And we humbly ask you to share this podcast, rate it, and leave a review, because this actually helps others find the show. Again, thank you for listening. And for everyone at Centura Wealth Advisory, I'm RJ Malik, reminding you to live your best day every day. And we'll see you next time.
Thank you for listening to the Live Life Liberated podcast. Click the subscribe button below to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Centura Wealth Advisory. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning. Centura Wealth Advisory, Centura, is an SEC registered investment advisor with its principal place of business in San Diego, California. Centura and its representatives are in compliance with the current registration and notice filing requirements imposed on SEC registered investment advisors, in which Centura maintains clients. Centura may only transact business in those states in which it is notice filed or qualifies for an exemption or exclusion from notice filing requirements. Past performance is no guarantee of future results. Tax relief varies based on client circumstances, and all clients do not achieve the same results.